Hi, my name is Andrew Meinzer of Meinzer Law Firm. This video is the fourth in a series about conservatorship court proceedings in California. In this video, we're going to pick up where we left off in the last video regarding having the court put someone in charge of another person through a conservatorship court proceeding. Where we left off in that video, we had filed a petition with the court and notified the proposed conservatee and his relatives of the court hearing. There's a bit more to the story of having you put in charge, so let's discuss it. Generally, 3 documents we filed with the court to help the court determine whether a conservatorship is necessary. First, we need to have a physician complete a document assessing the proposed conservatee's mental faculties. Also, a court employee will perform an investigation and file a report with the court to make recommendations regarding whether the court should approve the petition and create the conservatorship. Finally, and number 3, the court will appoint an independent attorney to protect the interests of the proposed conservatee. Although you're intending only to help, the court can't give you legal authority over the proposed conservatee unless it removes that legal authority from the proposed conservatee himself or herself. So the court wants to ensure that the proposed conservatee has an advocate to protect against the conservatorship being created for someone who doesn't need it. Now, fourth, in a limited conservatorship for somebody who has a developmental disability, there will be a report prepared by the regional center. Regional centers exist in California to provide assessments, determine eligibility for services, and offer case management services for people who have developmental disabilities. If there's disagreement regarding whether a conservatorship is necessary and/or who should be in charge as conservator, then somebody may formally object to the petition or even file their own competing petition. In that type of a case, a geriatric-psychiatric evaluation of the proposed conservatee, a mediation, or a jury trial may be required. All of these slow down the process. Fortunately, most conservatorship court proceedings don't go in this direction. If there's no formal objection or competing petition, then the court ordinarily will appoint you to be in charge as conservator as we requested. The court will generate 2 documents that will be your proof of your authority that you're in control of the incapacitated person. If this is a conservatorship of the estate that would give you authority over assets and income, then the court ordinarily will not generate those 2 documents until you file a bond with the court. Like a plumber's bond that would pay if the plumber damages your house, the bond in a conservatorship that will be required by the court will replace the value of the assets if you abscond with them. Not that you're planning to do that, of course. There's an annual premium payment for the bond. You can pay the annual premium from the assets of the conservatee, also called the conservatorship estate. And it's possible to have the court waive the bond requirement sometimes, which I'll discuss in a later video in this series. If not waived, and after you file the bond with the court will generate those 2 documents that will be your proof of your authority that you're in control of the incapacitated person. We'll discuss what you do with them and your other initial responsibilities in the next video. See you in the next video.